My name is Christy Myatt, and I'm a member of the Farm Credit team here at Nexsen Pruet. In this video, I will talk about how and when to deliver a DLR notice. A distressed loan restructuring notice is commonly referred to as a DLR notice. Once a loan has been found by an association to be distressed, the Farm Credit Act requires that the borrower be provided with a DLR notice. There are two types of distressed loan notices: a non-foreclosure notice and a 45-day foreclosure notice. The non-foreclosure notice tells the borrower that his or her loan has been identified as distressed and that the borrower has the right to request a restructuring of the loan. This notice is typically provided when the association determines that there is 1. A low likelihood of foreclosure, and 2. A high likelihood that the distress can be resolved. If the association sends a non-foreclosure notice, it must send the 45-day DLR notice before proceeding to foreclosure if the borrower does not apply for a loan restructuring, or if the loan is restructured and the borrower does not perform under the restructuring plan. An association is not required to send a non-foreclosure DLR notice first. It can proceed directly with a 45-day DLR notice. The 45-day DLR notice is best used when the situation causing the distress is sufficiently severe to create a high probability of a foreclosure action. The 45-day DLR notice informs the borrower that the loan has been identified as distressed, the borrower has the right to request a restructuring of the loan, the alternative to loan restructuring may be foreclosure, and if the loan is restructured and the borrower does not perform under the restructuring plan, the lender may initiate foreclosure without further notice. The 45-day DLR notice allows the association to proceed toward foreclosure without further restructuring notice to the borrower. However, the borrower must still be provided notice of the foreclosure action pursuant to state law requirements. The DLR notice should be sent to all borrowers on the loan, whether one or more, and regardless of whether one of the borrowers has been designated to receive notice. Notice should not be sent to any guarantors or third parties who have pledged collateral for the loan, as they are not entitled to assert borrower rights. With the consent of the borrower, however, a copy of the DLR notice can be provided to the guarantors or third parties. The regulations do not specify the means by which an association must send the DLR notice. The regulations specify that the notice must be sent in a manner that requires the borrower to acknowledge receipt of the lender's decision. An association should maintain a written policy describing what actions or documentation will satisfy this receipt requirement. For example, a DLR notice may be sent by regular first-class mail or hand-delivered, as compared to a ROFA notice, which must be sent by certified mail. The best practice suggests that a separate DLR notice be sent to each borrower and that the letter not be combined. However, if combined, make sure to list each borrower and address separately. If the borrower does not timely respond to a DLR notice, the association should, first, clearly document in the loan file all attempts to reach the borrower and all other alternatives pursued to comply with its obligation. Second, send a 45-day foreclosure letter if one previously has not been sent. Third, send a closeout letter indicating that borrower's rights have concluded. And fourth, proceed with its rights and remedies under state law. If you have any questions or need more information about DLR notices, please call me or any of the other members of the Farm Credit team here at Nexsen Pruet.